Hi, I'm Jonathan Wood, an attorney in Pacific Legal Foundation's DC Center, and today I'm joined by my colleague John Groen and one of our clients, Donna Murr, to talk about PLS's latest Supreme Court oral argument in Murr versus Wisconsin. Now, John, you argued this case in the Supreme Court this week. Why don't you tell us a little bit about what the issue is and where it fits into the broader question of the takings clause?
Okay, sure. I'll give you the legal part first, and then show you with the facts how the legal question is presented. But back in 1978, the United States Supreme Court issued a decision called Penn Central versus City of New York. And in that case, there's a particular paragraph where they said that in takings law, we do not divide a parcel up, but we consider whether the impact of the government regulation goes too far by considering the, quote, parcel as a whole. And so this case deals with, well, what is the parcel as a whole? And we've been debating that. That's been an issue before lawyers who are dealing with regulatory takings for all these years, since 1978. And now, in the Murr case, the court finally has the opportunity to address what that phrase means when we're talking about normal parcels of land. Mm-hmm. They've dealt with it in some strange contexts like air rights or moratoria or eagle bird feathers, things like that, but never dealing directly with land. And now they have the chance to deal with land.
And the facts of this case, I think, are really something that most people can relate to. Donna, why don't you tell us a little bit about your family's property and how this issue came to affect you?
Sure, certainly. My parents bought a piece of land back in 1960, so many years ago. They decided to build a family cabin on that piece of property. 3 years later, the vacant lot next door was still available, and my parents thought that would be a great investment for the future, so they bought the vacant lot next door as an investment. And it's sat empty and vacant for all these many years. My parents then, after many years of enjoying the family cabin, they gave it to us kids. There's 6 siblings that own the cabin, and the following year they gave us that vacant parcel, that investment parcel, as a gift. And so as years go on, the family cabin's going to take some wear and tear, and our family grew. And so as a family, we decided we wanted to expand the cabin, maybe make it a little bit bigger, do some improvements. And so we approached the county to talk about permits and that sort of thing. And in order to fund our project, we thought we would take advantage of this investment parcel that my parents had bought for our family, sell the land, and then use that money to fix up the cabin. But going through the process of learning what variances might be needed, what permits might be needed to fix up the family cabin, we learned that there was no way we were going to be able to sell or develop the vacant land next door. And we thought, well, how can this be? We've been paying taxes on this property. It's sat vacant all these years. It's grown in value, just as my mom had hoped it would do. It was serving the purpose that it was supposed to for an investment. And so we were quite shocked and flabbergasted that the county was not going to allow us to either develop it or sell it on its own. So we felt very strongly our rights had been violated. Our property rights were not able to be exercised. So we pushed forward, and we kept pushing. We went through the entire Wisconsin court system, unsuccessful. And as a family unit, again, lots of family support. We were all on the same page that we wanted to keep pressing for this. We knew that our parents would have pressed forward, that this case was so important that we kept fighting for our rights, so we kept fighting for our rights. And as we got to the point of going through the Wisconsin court system unsuccessfully, we decided we wanted to pursue an opportunity to go to the next level. And that's when, through the power of the internet and Google searches, we were able to find the Pacific Legal Foundation, who immediately embraced our case, understood our issue, and then petitioned the United States Supreme Court, and here we are today.
That sounds like a pretty harsh result. They're saying that this one piece of property you have, you cannot You cannot use it separately. You cannot sell it. You basically can't do anything with it. That sounds pretty harsh.
It is exactly what we felt, very harsh, very unfair. You feel like the government has let you down. They're there to protect you and help preserve your rights, and to have that feeling that they were stealing or taking your rights away, it kind of took your breath away. Like, I'm not understanding what's happening here. We're just taken aback. Like, this isn't real, that they're supposed to help us, not hurt us. And we felt financially hurt. We felt more that it was a matter of them telling us what we could do. When you buy a piece of land in a residential development, you have the expectation you can buy or build. Everyone around us is either built on their property, had the opportunity to do so. So then when we want to take our opportunity to do so and we're told we can't, simply because we own two parcels next to each other, that was the only reason. We just felt unfair. This isn't fair. When you look around, everyone else, so we felt singled out. Doesn't feel good to feel singled out. So certainly it didn't feel fair at all.
So to return to the issue, it sounds like this is a pretty easy case. They bought this lot. It's been treated separately as an investment. It's been taxed separately. Isn't that the parcel as a whole?
Well, you would think so, and that is the argument we make. But the Wisconsin Court of Appeals, in an unpublished decision and with no dissent, ruled that the 1978 Penn Central case that I mentioned, they said that coming out of that case is a, quote, well-established rule that if you have contiguous, commonly owned properties, you must consider both parcels together. So for the Murrs, the Wisconsin court combined both separate parcels and said that is your parcel as a whole. And that's why the Supreme Court granted review in this case, because it really isolates, okay, you know, can you take two legally distinct properties and aggregate them together? And of course, it makes a huge difference in the takings claim, because once you take the economic use that the Murrs have with the cabin on that separate parcel, and then you take that value and that use and attribute it to Lot E, it's a lot harder to prove a taking, because now the economic impact is diluted because you've increased the overall parcel size. And our arguments, of course, are that Penn Central actually stands for the view that the parcel as a whole is the single parcel, the fee title. And that's just based on common understanding of real property law. It's based on the law from the Supreme Court, both in the Penn Central case and another one called Tahoe Sierra, where Justice Stevens, writing for the court, described that property interests are defined by the metes and bounds, the geographic boundaries. And that's what we're dealing with here. And so our position is that the separate parcel, Lot E, the investment parcel, is the parcel as a whole, because that is the parcel that's been restricted, been regulated. It is the single parcel. And so whether there's a taking of that parcel should be measured by that parcel alone, and not because the Murrs happen to own the adjacent property next door.
So you argued this case in front of the Supreme Court this week. I believe it's the 11th Supreme Court case that PLF has argued in front of the nation's highest court. What was it like when you heard that the court had granted your case, and as you prepared for, what is the pinnacle of any lawyer's career? Yeah,
it's well, when I actually learned that the court granted review, the court had been spending several weeks. Each week it comes up and it was redistributed again, which meant they were considering. So we knew, okay, we have their attention. And the morning that it was granted, I was sitting at my computer and going through my email, and then boom, there's an email from the clerk of the U.S. Supreme Court, and I knew something just happened. And I was alone in my office and opened that email and saw the order Murr granted and just erupted with joy, And of course, word immediately was throughout PLF, and we were celebrating because we knew this was a great opportunity for the Murrs and a great opportunity for property rights and people in general, because this issue needs to be addressed. You know, the takings clause in the Fifth Amendment, we can talk about the legal nuances and parcel as a whole and everything, but the purpose of the constitutional protection is for our individual liberties, and that's the Murrs' liberties, their property rights, but everyone else. And that's why we're here. That's why we do this, to try and get these kinds of cases before the Supreme Court. So it was an exciting moment when that happened, yeah.
Yeah, I'm sure the individual story is, of course, compelling and probably what got the court's attention. But what was it like for you? Did you ever think that this issue affecting your family would reach the nation's highest court?
We dreamt about it in kind of fantasy world. So then when it actually happened, it was very hard to believe. We had all learned so much about the Supreme Court through the process, trying to re-educate ourselves about all the things you learned growing up. But to learn that they have about 10,000 petitions a year, and they only pick about 80, and then to find out you were one of those, we describe it as winning the lottery. I mean, that's your initial reaction. You feel like you won the lottery. So it was exciting, is even close to the right word to describe how we all felt. Unlike John, I was on an airplane at the time with no Wi-Fi. So as soon as I landed, I turned on my phone and I got John's email, said, "Murr, granted." Unfortunately, my husband was a few rows behind me in the plane. As soon as I could, I stood up. I'm like, "Tom, we made it." And I started crying. And it was one day I will never forget.
Well, I believe that was back in January 2016. You've had a pretty long wait to get to this oral argument. What was that like?
Well, since we've been at it 12 years now, we're good at waiting. It's not fun, but I think we're good at it. So we'll wait some more now, it sounds like.
Well, of course, I'm sure we all hope that the decision comes down quickly. But John, tell us what it was like to actually be in the courtroom. I don't know whether our viewers know, but the attorneys are brought in about 20 minutes before the justices enter the room. And so you sit there in the front watching the clock slowly tick. What is it like as you approach this very exciting opportunity?
Yeah, it was a very interesting experience. You first head into the lawyer's lounge, and you're in there with your colleagues who are going to be at the table with you, but also with the attorneys on the other side. And so I was able to meet them and exchange greetings. And then the lawyers who are arguing the next case are in there as well. So it's an interesting time in there, and everybody is realizing that we're about to head out to the courtroom. So there's I would call it a healthy level of anxiety. It's nice, and then off you go. And I remember the feeling as I was walking into the courtroom, and the justices are not in there yet, but the seating is full. Everybody is in place and ready to go, and it was a packed courtroom. There was not a seat left. Many people who wanted to get in could not. So you feel the energy of all of that, and of course the setting is an amazing courtroom. And one of the things that strikes you, I knew this was the case, but when you actually sit down in the advocate's chair right next to the lectern, you realize you realize ahead of time because you know the fact. But when you sit down in that chair and you stand up at the lectern, you feel how close you are to the Chief Justice. You're right there. And I actually really like that because it makes it so that it's not an oral argument. It's a discussion. You want to have a discussion with the justices. And so, all that excitement builds, and you do sit down in that chair, and there is another 20 minutes or so. And of course, I started going over my notes, and you just kind of build for that moment. But as expected, once I started, I got about 2 sentences, literally, and the first question came. And you prepare your notes, and you have all so many things that you're ready to go with. But the reality is, once the question started, I don't believe I ever once looked at my notes through the entire argument, because you just go and it's all in your head, and you really don't need to look at your notes. You know where you want to go with the case and the argument. So it was exciting. Wouldn't trade it for anything. It is what, as a lawyer who wants to change the law and set precedent in protection of constitutional rights, it's why I'm at Pacific Legal Foundation. And so it was great to be able to have that chance.
Tell us a little about the discussion. Were any of the questions surprising, or did any stand out to show that at least some of the justices really got the problem at issue in this case?
There were all kinds of things, but a few things I think were really telling. I really appreciated when Chief Justice Roberts was asking of Richard Lazarus, who argued for the county, about whether or not, he asked, would these parcels have merged if it was a husband and wife, and each the husband had the name of had the parcel in his name, and the wife had the other parcel in her name? Would they merge? And he's like, no. What if the Murrs had put one parcel in two of the siblings, and the other parcel in the name of two other siblings? Would that change? And he said, yeah, we would view those as separate parcels still. So he's pointing out, I think he used the word quirky. Well, this is a quirky deal that the county has going here. And that's all important to the legal issues, but it demonstrated to me that Justice Roberts was really, he had a laser on some of the weaknesses, I thought, in the county's argument. So some things like that were very interesting.
Yeah, those examples certainly make it sound arbitrary. Now, Donna, as a client, what is it like to be in the courtroom when you're not the person at the lectern, you're not getting to speak, you're just watching? Yeah. What's that like?
It's nerve-wracking. It is stressful. I've had a few days to reflect, and I compare it to watching a sporting event where you're rooting for your team. Although it's fun and exciting and competitive, it's stressful because you want your team to do well, and when somebody's picking on your team or going against you, it's very exciting, but my heart raced a few times. I didn't like some of the things I heard. I don't understand the arguments on the other side so much, so it's frustrating. You want it to just be all positive in your favor. Of course, it's not going to be. It is what it was, and it was an experience I will never forget. Certainly, having had a couple days to reflect, it is definitely the most exciting day of my life. I'm in what I call post-argument day euphoria. I will never, ever forget it. And what's so special, too, is that we had 21 family members there. And we did all get in. And so to experience something like that with your family, the people that are most important to you, I'll never forget it.
Well, Donna, I'm sure I can speak for all of PLF when I say that we were so happy to be able to be there with you and your family on the most exciting day of your life. And we look forward to the decision from the court and are confident that the court will reach the right result. So thank you both so much for being here with me today, and we look forward to seeing the court get this one right.
Thank you much.
Thank you.